Welcome, everyone. I think we still have some folks rolling in to the meeting here, but we're going to go ahead and jump in and get started. So I'm going to start off with some belief statements. I believe that family land should be a part of a family's legacy, but that often can become a curse. We believe that undivided interest in family land is one of the greatest causes of discord and division in farm and ranch communities. And we believe that informed options lead to action, action leads to clarity, and clarity leads to peace over time. A few years ago, we were working with a family of 4 siblings, ages 60 to 70. They had 3 ranches to divide, all undivided interests left to these 4 siblings. Unfortunately, the tension had been mounting between these siblings for decades. And it wasn't until one of the siblings became terminally ill that they decided that they needed to manage this ranch land. They had children, they had grandchildren. And so as these 4 siblings sat across the table from each other, they finally had alignment that something had to be done. Now, as we worked with them over the next 6 months, we went through some tough and sticky conversations with dividing 3 ranches. And the whole time, I couldn't help but notice the one sibling that was diagnosed with that terminal illness. She was tormented because with the few days that she had left in her life, she had to watch her siblings argue about who got what. And I don't think that's what she wanted. I think she wanted to find peace and joy in the time she had left with her siblings and her family. Now, I believe that that could have been avoided. And that taught me a few things, amongst other situations with family members. That taught me that parents really shouldn't leave it to their children to decide when it comes to dividing land. And that waiting for a crisis just creates more stress. And I also believe that the more decision makers there are at the table, unfortunately, the harder the conversation gets. My name is Cody Musick, and I'm the president of Waymaker, Surveyors of Land, and the founder of Survey Texas. My team and I, we provide farm and ranch land surveying services across the state. Our heart and mission is to help families stay united when dividing the land is unavoidable. And that's what we specialize in. Now, I have a lot of stories I could share similar to the one that I just shared with you, but we don't have time for all those stories. So without further delay, I want to make our intentions clear of today's webinar, and I want to introduce today's guest speaker. Our intentions today is to pull time forward for families by identifying solutions and some common mistakes families make when preparing or executing their estate for the future generations. We're going to do that by first looking at insights and options through this conversation with Chris. We're going to give you some free resources and connections, and we're going to encourage you to take action sooner rather than later. Today's guest speaker is Chris Schoessow. He's an attorney and partner at Bryla and Schoessow law offices in Fredericksburg, Texas. Chris could have been a 3rd-generation surveyor. His grandfather and his great-grandfather were both surveyors, which gives him an interesting insight into what we do as surveyors and the value we provide in our profession. I've had the pleasure of getting to know Chris over the past few years as we worked with families and projects to solve problems and to help us families manage their estate and their land, which we hope continues to be their legacy. So without further delay, I would like to introduce our guest, Chris Schoessow.
Thanks for having me, Cody. It's a pleasure to be here.
Yeah, glad you're here. So, Chris, can you tell us a little bit about your practice and kind of where you come from? I know that you're a Baylor graduate, law graduate, 20 years of experience, I believe, in estate, probate, and business law. but tell us a little bit more about what you do to get us started.
Well, thanks, Cody. My wife and I both graduated Baylor Law. We initially practiced in San Antonio for approximately 7 or 8 years before moving back to Fredericksburg, which is where I was grown and raised. And we had 3 small children, so we decided San Antonio wasn't the place for 3 small children. So we moved back here in 2011, and we've both been practicing ever since in the estate planning field. A lot of times people think estate planning is doing wills and doing probate. Well, it's really more comprehensive than that. What we like to do is, estates involve all sorts of things. They involve real estate, whether it's a house, whether it's a commercial business, whether it's a farm or ranch. They involve businesses, family businesses. And so we like to help everybody by being able to advise on all of those topics, because they all come together, in my opinion, in somebody's comprehensive estate plan.
Yeah, that's really true. I think a lot of people, that probably gets overlooked on the family business side, but I can imagine that's a pretty important piece of it for what you do.
Especially here in Fredericksburg and the surrounding cities, because there's a lot of small businessmen and women. So whether somebody has a sole proprietorship, whether somebody has an entity that they run a business through, a lot of times that does get overlooked, in the succession planning, especially on this.
Yeah, I believe it. Well, one of the big focuses today is, especially being land surveyors, is specifically talking about how families can better manage land ownership in the family as it goes from one generation to the next. And we both know that's where a lot of tension seems to mount, and that's where families can unfortunately find themselves very divided. It's funny, as I was doing some research before this conversation, one of the things that popped up was that when it comes to undivided interest in land and families and in estates, is one of the reasons that undivided interest is a vehicle, a mechanism that families use, is because its intent is to maintain unity. But I have to tell you, Chris, more often than not, the undivided interest is the source of division, especially amongst siblings that are left with land and they're all trying to figure out what to do with it. So if you, in an ideal situation, Chris, when a family comes to you and they need to manage their estate, land included, where do you like to start with a family?
Well, I like to start with meeting with, if the parents are still around, I like to start with meeting with the parents and seeing what their ideas are. Do you have different pieces of property? Do you have the ability to have one piece of property go to one child, one piece go to another child? If you don't, and you have one ranch, do you have the ability to survey that ranch in half and say child A gets the west side, child B gets the east side? And so, I like to bring that thought into their mind, and then we'll go through and tell them stories like you initially stated, that there can be a lot of discourse between siblings if they own undivided interest in properties. So usually that'll start the thought. Now, they may have already thought about it and been proactive, and they may have said, all right, we already had Cody survey this ranch into 3 chunks, and child A is getting the west side, child B is getting the middle, child C is getting the east side. So, and that doesn't leave it up to the kids down the road.
Yeah.
It's done. It's in their will, and that's where it becomes the easiest for us and for the children going down the road, because they don't have to deal with it. Now, I also like the parents to get the kids involved in the discussion, because they can bring it up and say, what do you guys want to do? We want to do what you guys want if we can. And so that starts the discussion between the kids. Now, that may result in a premature argument because they just didn't agree on the outset. And then it's up to the parents to decide what they want to do. Do they want to leave it in undivided interest for the kids to settle down the road, or do they want to go ahead and make that decision for them?
What do you think is usually the cause of delay in making that decision more proactively than just letting the siblings figure it out 20 years later? Like what usually causes, someone to default to undivided interest?
I think it's the easiest, quite frankly. It's either the easiest because they can say, all right, well, we're not going to make that tough decision right now. We don't want to cause problems within the family while we're still alive. We don't want child A to be mad at me and go move to Mexico and never see us again. But sometimes, Cody, there's that opportunity to divide it between them fairly isn't there. I mean, there may just be a small piece of land, in the ETJ. There may just be a rent house, and a lot of times it's hard to offset and it's hard to make everybody exactly equal. And so I tell clients all the time, if you've got real estate and you're wanting to divide it between your beneficiaries and your wills, it's not going to be penny for penny equal unless you direct the executor to sell all the land and split the money. So I advise clients just to be as fair as you can. And if you've got two tracts that are approximately the same value, then so be it. It's not going to be exactly equal, but that's better than giving an undivided interest in both of the tracts.
Yeah. I do agree with that, Chris. That's one of the hardest things we do is when we start working with families to divide land. A lot of times those families they've grown up on that land. Maybe they grew up working cattle on it. Maybe they grew up hunting on it. So I mean, it's not just a piece of dirt to them. Like it's memories. There can be a lot of emotion around, that land and the idea of dividing it. But on the flip side, what we see is if they don't do that, then liquidation obviously a lot of times becomes the answer, because if they can't agree on how to divide their interest, then I know sometimes you see it go to judgment and the judge just says liquidate it. So
right.
And that's kind of the last resort, right?
It is, and sometimes that comes sooner rather than later. So what you're talking about is somebody filing a suit for partition, and that comes when somebody doesn't agree with how they want to divide the property. And so one of the bad things about undivided interest holders is any of the owners can force a partition or sale and file a suit at any time. So they can say, I've got an undivided third interest in this property. I'm going to file a partition suit in district court. They're going to set aside some commissioners. They're going to get a surveyor. They're going to get an appraiser. Can we partition this by dividing? That's the first question.
Yeah.
And if they can't, then they force it to be sold. And so the one who wanted to hold the property or wanted to run the property or ran his cattle on the family property, they don't have the property anymore following the sale. Also, what clients, a lot of people don't know is if you do file a partition suit and you don't come to an agreement ahead of the judgment with your siblings, you don't have any control over which parcel you get if it can be divided. It's basically up to the judge and the commissioners at that point. So, I try to get clients to come to an agreement where they may be off an acre or two somewhere, but at least they're getting the big chunk of what they want as opposed to doing a coin flip.
Yeah. No, that's a great insight. When you have, let's say you just find an example here. Let's say there's 600 acres to be divided. One of the things that has to be considered is equitable value, not necessarily equal acreage, right? So
Right.
if part of the land has road frontage, or maybe it's got certain features or assets that make this portion of the land a little more valuable than the other portion. Well, maybe one of them's got a home and a well and electricity on it, and the rest of the land's raw acreage. All that has to be taken into consideration when you look at, is it equitable how you divide it, right? It's not acreage for acreage, right?
That's exactly right. And that's what comes up the most is, well, you can bale hay on this and I've got a rock out problem. I've got this hill over here that I can't graze, but I've got a good home site. So, and believe me, when we're talking about clients dividing up pieces of property like that, you hear every single bit of that. This one has pretty oak trees. This one has oak wilt. All of that comes into fruition. And while there's not necessarily a way to get those values monetarily. Yes, we can get an appraiser and say, hey, there's a ditch over there I've got to drive through, so I have to maintain that on a more frequent basis. People have their own ideas what the equity is in that piece of property. So yeah, those values do come into play with all the different aspects of the property.
Yeah, no, that's good. Well, another reason that we see undivided interest being leveraged in these transitions of ownership, or setting up these estates, is sometimes they refer to collective control. So, if let's just say let's say it's a ranching family, and it's 2,000 acres, for example, and let's say all three siblings still farm and ranch, so there's some collected interest in when certain activities happen, certain times of the year, how much money are we going to spend on fertilizer this year for Coastal, or how much, maybe they share a herd of cattle and they have to decide how to manage that. So we know that there's benefits in that collective control, but can you think of anything on the other side? Do you have any examples or anything where that collective control kind of works against them?
So I think, Cody, the collective control in the example that you just gave is by far the exception to the rule. Where you see that situation where siblings are still working a ranch, whether it's farming, ranching, hunting, that's probably the older generation still, because they've done that their whole life. I think if you come down to the younger generations, a lot of the siblings are spread out. So you may have one person who lives in Fredericksburg and is quote unquote running the ranch. You may have somebody who lives up in Dallas and may or may not get down very often. You may have somebody that lives out of state. And so that collective control really only works when either everybody's involved or people are passive in their involvement and say, okay, brother, yes, you can take care of that. Just send me the check on a monthly basis. But no, I think more it's the opposite, where if you have people coming together and owning undivided interest in properties, they're going to have differences in opinion. So it won't be a collective agreement. It's okay, well, I want to run soybeans now instead of corn. Well, we've been running corn for 10 years. Or I want to put cattle on this pasture. Or let's get a little more income and have some hunters come in. And so there's just so many ways that you can get a difference of opinion. And, I will tell you that I have family land in our family, and we own it in undivided interest within a partnership. But you have the same problems with that as well. Not everybody's got the same ideas. So it is an issue, but it can work. But I think that's the exception. One of the examples that I thought of that is probably the most easy one to think about is, let's say that two siblings own a rent house in town together. Both of the siblings, don't need a ton of money. They're both doing okay. They get a management company to run the rent house, and they get a check on a monthly basis. As long as they agree to run that as a rent house, I mean, that's the easiest situation possible. But I think the more common situation is, let's say we have 100 acres in Fredericksburg or around Fredericksburg. Somebody lives close here and maybe runs their cattle on it, maybe gets to hunt it, but on the flip side, has to do all the work on it. Somebody lives out of town and they say, I've got an undivided half interest in this very valuable piece of property, and I don't get any benefit from it. I'm not down there to use it. I don't get to run my cattle on there. I don't get to hunt on it. But on the other side, they're not doing any work either because they're not around. So that's where the situation becomes testy. Most of the times we see, because not everybody's on the same page.
Yeah, that's a great example. We also know another reason that some families use undivided interest is I think there's some tax benefits, or there can be if managed properly. So can you talk a little bit about, actually, I'm gonna put this question down a little bit, and I'm gonna ask you a different question. More of a broader question is, more about like what's going on kind of in the industry in the tax code, tax law. And I realize you're not a CPA, and this is a conversation. It's not legal advice, right?
That's right.
So, what kind of information do you have on current developments as it relates to estate planning and taxes? Has there been any big changes recently that folks need to know about? Some benefits, some tripwires. So let's just talk about what's going on in the tax and estate world.
Sure. One thing that everybody always asks is, am I going to have to, my kid's going to have to pay tax when I die? So, the estate tax has been a question, of interest for a long time. If you go back to sounds like it's not that long ago, but if you go back to 2003, our estate tax exemption was $1 million per person. And, that seemed like a lot back then. Well, now you look at our land values and, the values of the residences in town going up, the raw land going up as well. Over the last 3 years, it's increased immensely. The values have. Well, with that, President Trump came in and increased our estate tax exemption to $10 million a person in 2016. And so everybody was pretty much fine as far as not owing any estate taxes. That's continued to increase with inflation. And so right now, today, each person's estate tax exemption or lifetime giving exemption is $13.61 million per person. And I know everybody's like, well, that doesn't affect me. Well, most people it doesn't. What we have on the horizon, though, is Trump's tax breaks and the estate tax rates are set to sunset at the end of next year in 2025.
Ooh.
And then what that means is they're going to go back to the estate tax value when President Obama was in place. And so that's $5 million per person. And I know a lot of people think that, well, that's still not going to affect me. But I think it certainly can, because one, real estate is going to continue to appreciate, maybe not at the same level it has in the past 3 years, because it's definitely leveled off a little bit the last year. But two, if you don't plan correctly, and let's say I pass away and my wife receives, all the land, now her estate is the $5 million exemption as well. So if I've, dumped both halves on top of her, that may cause a problem in the future. So we had something kind of like this in 2012, where the tax rates were supposed to sunset back to $1 million per person. And we had people using their $5 million exemption to go ahead and gift large chunks of their land out of their estates, so they wouldn't get hit with a bunch of estate tax. Because if you own 100 acres around Fredericksburg with a house on it, it's a valuable piece of property. So, but yeah, that's kind of what's coming on. And I think people are going to start talking about it a lot over the next year and a half, because that is, unless Congress decides to do something different, which we don't find very likely, we think it's going to go back down to $5 million per person.
Wow, that's a huge shift for families that hold a lot of land, right? So I mean, if those, especially with the appreciation, if you hold much acreage, it doesn't take long to get past 5 million.
That's right.
Not given the size of Texas and the size of our rural properties, especially.
Right.
Well, and that leads me to, that's a great point. Thanks for answering that question. Let's talk just tax benefits in general of an estate, and let's get a little granular. Let's say we have an example where we have some siblings that maybe they have, or some children that have received an estate. Let's say it's worth 15 million. I realize that's above the tax limit there, but let's say it's some land and it's worth something, and let's say it's an undivided interest. What do you recommend, or what do you see as being some options for them as that land is handed to them, to both A, protect the unity in the family, and B, protect their tax liability in that? So just What do you think on something like that? How do you see that tactically kind of playing out if that family comes to you and is like, where do we go next?
That's a great question, and I'm going to give you the standard attorney answer, is it depends, right? Everything depends on the facts that you've got. So, they can first you talk to them and say, is it an option to hold the land together, right? Can y'all work with it together? Can you come up with an agreement to who makes the decisions for the most part? And if that's an option, then we start talking about, okay, well, how can we own this together as an undivided interest, but in a better way? And so a lot of times what we'll do, if people want to continue to own the land together and collectively, then we'll suggest forming a limited liability company or an LLC. The benefits of that are several. One, you just deed the property to the LLC. LLC provides liability protection both inside the LLC and outside. So if something were to happen to one of the siblings on a personal basis, they couldn't come inside the LLC and take the land away from them, or they couldn't take the ownership interest in the LLC. On the other side, if something happens on the property and somebody gets hurt, it can't get outside of the LLC to the personal assets of that sibling. So, and it may be something where they say, John is going to be the manager, so he gets to make all the decisions. I don't have to do anything. So if they want to work it together and it's feasible, then that's usually the first thing we'll throw out there and suggest, just because it does make things easier. You don't have 3 different people getting tax bills. You don't have to ask somebody for their 1/3 of the feed bill every month. You could just set up an LLC bank account and just say, all right, make your $5,000 deposit a year, and then we'll just go from there. So if they can work it, that's what we typically suggest. If they can't, then we suggest, okay, well, how can we split it? Is it possible to be split? And it may or may not be. And then that's where you can come into some problems. Now, I had some clients a couple of years ago who, like you said, received an inheritance, and it was co-owned with the siblings, and they were fine. And it was several different pieces of property. There was a house in town. There was, 70 acres somewhere. There was 15 acres somewhere else. And even though the siblings got together and they were perfectly amenable with owning it together, they didn't want to wait to get to the next generation, because while they had a good relationship and they all lived here, they could take care of everything. They didn't want to take that chance of causing a problem for the next generation. So they just went ahead and agreed that, John was getting this and Sam got this, and they split up the 75 acres into 3 different tracts, and, one got that. And so they took care of that proactively. And, for them, I think it was the right thing to do. Could they have owned it as undivided interest and make it work? Sure. But they wanted to jump out there and take care of it for their kids.
Yeah, they wanted to get in front of it before it became a source of tension and division. Yeah, especially as they were, I'm sure, getting ready to set up their own wills and estates and set their kids up for success, right?
Right.
Yeah.
Now one thing, just from a historical standpoint, Cody, and sorry to jump in.
Oh, go ahead.
I think one of the reasons that you see a lot of undivided interests in and around Gillespie and the surrounding counties is because the plan, starting back in the 60s and 70s was, hey, we're going to start to trickle this land out of our estate for estate tax purposes. So we're going to give an undivided 10 acres, 20 acres. And so people would just get on a gifting regime on an annual basis, because you were allotted so much money that you could give worth of land, that you didn't have to tell the IRS, you didn't have to file a gift tax return. And so people just got in the habit of doing that. And then, which made sense up until the late 90s and early 2000s, when the estate tax exemption was $675,000 a person, or $1 million a person. But now, if you look at the estate tax exemption being so high, coupled with the fact that our annual gifting allowance is $18,000 this year per person. So that's maybe 1 acre in a lot of places. So it's not going to do you a bunch of good anymore to do that, because the land values have increased so much, and the gifting amount where you can do it tax-free hasn't increased that much. So I think that's where a lot of the undivided interest came into place, is because people had those gifting plans every year that they would do. And so now I may come in and say, it's not worth it to do an undivided acre gift this year, but you still did an undivided 80 acres in the past. So that's where we're stuck with a bunch of that.
Yeah. Yeah. Yeah, we see that a lot. Okay. Well, one other question I have for you, well, a few other questions, and I don't know how we're looking on time. Looks like we got about 10 more minutes to go here. What about title, Chris? Kind of where do we run into challenges, and how can families kind of look at where they're at based on how the land is held, whether it's held in their personal name or it's in an LLC. And then when you get ready to take that interest and set it up to hand off to the next generation, kind of what do you like to see there? What's the most helpful?
So I think the first thing that people need to realize is, if you don't have a will or estate planning documents in place, you definitely need to. Sure, Texas, if Texas has rules that if you pass away without a will, where your assets go based on the laws of intestacy, which says, oh, it goes to my spouse or it goes to my kids. But that can get pretty tricky because there may be separate property, there may be community property that's handled differently. So, there's probably only about 40% of people that have wills in place. And that's the best place. That's the best place to start. And it doesn't have to be anything complicated. It doesn't have to be tricky. It can just say, if I pass, everything goes to my spouse, or if my spouse doesn't survive, to my kids. But that's also where you can look at, all right, well, are we going to be able to divide our land between our kids in our will, or do we kick it down the road for them to do it?
Yeah.
So Texas does have rules that says if you don't have a will, that's fine. We'll tell you where it goes. But a lot of times that results in unintended consequences, because you may not have children, and it may go to a brother that you despise since third grade because he kicked you off your bike. But that is where you can, if you want to make charitable bequests, you can't do that if you don't have a will. Your kids can do it on your behalf, but they don't have to. So the will is definitely the most dynamic estate planning document to have in place. Also, powers of attorneys. This comes in title situations a lot where somebody may not have the capacity to sell the piece of property, so their spouse has to sign for them if they've got one. Somebody may be out of town, and somebody may need to sign a power of attorney appointing their sibling as their agent to sign the closing papers. So powers of attorneys are important too, because we end up using them a lot in real estate transactions.
Oh, that's good. I think that's a great way for us to, it's a good place to wrap up there. So the last question I have is kind of goes back to my first question, is your preference is that when you start the process of helping to put someone's estate together or making decisions, is that you have a chance to talk to the parents, the person that really probably has the bulk of the control, and obviously bring the children into that, whatever, assuming they're of decision-making age. But what do you recommend if those parents have passed and they're kind of, the dust is settling, the siblings are trying to kind of start figuring things out. So let's say there's not a parent involved to help make the hard decision.
Right.
What do you recommend in that situation?
Well, that would just be we'd have a family meeting, with the siblings, and then we'd see where we are in the process. Have the parents' wills been probated? If they have, then how do you own title to the property? What assets are there? Because a lot of times people can agree to shift assets around in an estate. So let's say there's a bunch of cash. Let's say there's some real estate. Well, somebody can get the cash if they want to, and somebody can get the real estate. They can agree to do that. So, if it says I give my kids an undivided half interest, that doesn't necessarily mean you have to split every single asset in half. Someone can say, all right, well, you can take 15,000, I'll take the old Jeep. So
Yeah.
it's just a matter of sitting down and saying, where are we? What are our options? And then how do you guys want to move forward from there? And like I said, there's times when undivided interest works. It's usually not the norm. It's usually, somebody coming in and saying, my brother did this on the property, I wanted to do this. And I think a lot of people understand that. So I think the good thing is just to have the initial discussion. One, if the parents are there, what do they want to do? Or what do the kids want to be involved with that decision making? But it may be a decision, or maybe a situation where we're already there. I mean, parents passed, kids have an undivided interest. It's just a matter of weighing the options and seeing what's really viable.
That's good. Well, I think as we wrap up, one of the things I want to be sure and say here is that I really challenge. Well, first of all, Chris, thank you so much for your time here. I think there's a ton of insight gained there. I've taken a ton of notes. I'm probably going to be calling you pretty soon and saying, hey, explain that to me a little bit more. Even though I deal with this every day, there's depth and complexity to it. And I think that's why I really believe families need to get professional help as quickly as possible. And so that's the challenge, is if you're watching or listening to this and your family dynamics are great and the family communicates well, you're in alignment, you have general agreement, then call that meeting and really just move to the next step. Don't let it delay. Don't let it wait until someone gets sick or there's a crisis in the family. If times are good in your family, like really move towards making a decision there. And on the flip side, if your family dynamics are tricky and challenging, then get with professionals as soon as you can. Get them involved. Because they've seen it before, right? So as a family, this may be the first time you're experiencing this challenge, and it can be hard. But the professionals like Chris and like us on the survey side, it's not our first time we've experienced this. And we can come to it with the experience we have. You can draw on that depth of experience, and we come objectively. We don't have favorites in the situation. We want what's best for the family, create unity, hopefully have, an equitable position for everyone. But sometimes you got to get some professional help to get there. And so that's our call for you today. We invite you to reach out to us. You can schedule a discovery call with us. Our phone number is 817-997-3884. You can email us at info@waymakerfbg.com or info@surveytexas.com. And we would be glad to connect you with professionals like Chris. And whether you need an attorney, maybe you need to talk to a professional tax consultant or a CPA. Maybe you already know what you need to do with the land, and you need a third-party appraiser. Well, we know those too. So we'd be happy to walk through this with you and help you make wise decisions for your family, your land, and your legacy. Thanks for being with us, and we look forward to talking with you again. And just a correction to make sure we get our phone number right. It's 830-997-3884. Give us a call. We would love to visit with you. Thank you so much.